I said, I don't want anything more to do with you or this case. I said, I've helped you as much as I'm going to. I said, but I am not going to be blamed for the fact that you, sir, are an idiot. Okay? This was about 7 years ago. So the upshot of this is the guy he's working for gets 10 years and a $4,000 fine. Does 7 months in jail, gets probation. You know, now he's a convicted felon. Now he's lost his right to own guns and can't ever work for the government, though who'd want to. And about, 3 years later, they come after the poor guy who had let him store his stuff there. Had nothing to do with it. And so this guy comes straight to me. He says, Brown, he says, I don't want the guy that, you know, my buddy had, because I don't want 10 years. I don't want a $4,000 fine. I said, oh, okay. Well, in the process of this, these idiots from the sheriff's department, and they'll do this stuff all the time, they had a search warrant to search this guy's truck. They didn't just search the truck, they took the truck. And they kept it for 3 years. So he wants his truck back, plus at the same time he's also been charged with a criminal offense because he's squealing about getting his truck back. So we file this little puppy here, okay? Now, this shows you, you can connect the dots with this case, what to do in a Fourth Amendment case. All right, obviously you're going to have to polish it a little bit in your own particular case. But here was the upshot of this. What we did in this case was, first, we filed, he'd already been charged with a misdemeanor on this, practicing medicine without a license or some nonsense, because I guess the sheriff's department wanted to keep his truck. His truck was worth about $2,500. And so here's what I said, here's what we're going to do. We're going to sue these people in federal court, and we're going to ask that you, because I said, you know, your truck really isn't worth much, so instead of selling them the truck, we're going to rent it to them. Okay, and I figured it's worth $30 a day for 3 years. All right. So then, of course, on the misdemeanor side, Dwayne Rogers lined him up with an attorney. We went as far as we could go with this, but this guy was kind of a flibberty gibbet, and I told him right up front, I said, you know, you ain't wrapped tight enough to stand on your own hind legs and fight this case on your own. Got the misdemeanor dismissed. Make a long story short, this thing finally winds up in front of a federal judge, a Clinton appointee. And I told him, I said, you know what? I said, Harry, I said, this thing here, I said, it's not worth very much. I said, so here's what I want you to do. I want you to go, when you go in front of this judge, and when you have the settlement conference, I said, the other side's already offered you $5,000. I said, I want you to tell this judge you want $12,500. I said, because what the judge is going to tell you is, this isn't worth $12,500. All right? I said, but that way you have a little bargaining chip here. I said, they'll probably knock it back down. The judge will probably tell you it's not worth more than 10, and let's see what happens. So he goes to conference in the judge's chambers, and he's sitting there with the attorney for the county where they gleeked this truck. And it's kind of hilarious. I mean, some of these cops are so stupid. And I'm talking sheriff's deputies. Big city cops, they seem to be wired a little tighter. But some of these county mounties, I mean, it's almost as if they have an IQ ceiling of 85, and if they get above that, they're not employable. Okay? Well, these fools hadn't read the search warrant properly. It was a search warrant to search the truck, not to take the truck. They couldn't tell the difference. So they're sitting there, Harold and this other guy, and the guy said, Judge, Your Honor, you know, this case isn't worth more than $5,000. And so the judge turns to Harold and he says, well, you know, this case isn't worth $12,500. And Harold says, oh, really? What's it worth? And so finally, the judge gets these people from the county up to $8,000. And Harold says, you know what, Your Honor? He says, let me explain how this is going to work. He said, I'll settle for as little as 10, but a nickel under goes to trial. And so the judge says, just leave the room for a minute. Comes back in, and the judge says, okay, they've agreed to 10. All right? And you'll see the proof of this if you go to the last page. You'll see the settlement. He got $10,000 for a truck that was worth $2,500, plus they had to give the truck back. So don't let anybody tell you you can't win this stuff. You can. All you got to have is a judge that's doing what he's supposed to. Now, another thing that's very basic here, It's called a master docket sheet because, like I said, we've got so many new recruits here. This is the sheet. And the reason it's placed here so you can look at it, you'll have an idea of how it goes. You can match this up. If you look at, turn to the second page here, the entry 52494, number 1, complaint. All right, that's the document you just saw. Okay, and what this does is this just comes down and it's a day-to-day record, a summary of what has happened in this case. And if you go all the way to the end, stipulation and order of dismissal, that's because we got the money. Okay, now let me backtrack just a second here on this particular case because, and I'm just going to take just a couple minutes with this. When you lay out a complaint, lay out a lawsuit, remember what I said, connect the dots, you have a statement of a case, not necessary. Jurisdiction tells the federal judge what right you have to park this puppy in federal court. Parties, that's just who is suing whom. You start off listing the plaintiff or plaintiffs, then you list the defendants. And the way you're supposed to do this is you'll notice there are numbers on the left-hand side of the page. Well, you had either better have these numbers here on each page, or you had better number your paragraph. If it's plain paper, you'll see that a little later on. After telling the judge who the parties are, you give them the facts. Remember I said you got to be brief. Learn what the facts are. Legal claims, all right, that explains what the law is. Now, what you're going to see here on the legal claims, all right, there were 3 causes of action we raised. 2 of them got flamed, but we didn't really think they were going to fly anyway. What I normally do, all right, and this is not considered accepted procedure, is that when I put legal claims in a complaint, I put in all the case law. I mean, I hit them with everything in the kitchen sink. The attorneys don't do this. Well, the reason I do it is because I want the appellate court to understand that if this judge at the district court had read this sucker, he'd have seen what the law was, and it would have gone to where it was supposed to. In this case, it did anyway. And finally, you have relief requested. You have to tell the judge what it is you want. You don't put in relief requested, you don't have a case. You don't serve it against the opposing party with a summons form, you don't have a case. Okay? Now, back to the master docket sheet. You can take a master docket sheet like this, and it's amazing how many attorneys don't know how to read one of these suckers. You'll notice the date is to the left, sometimes it's the number, and the numbers go down 1, 2, 3. This is in chronological order of what has happened in this case. And to the right, like I said, there's normally a 1-sentence summary of everything that took place. If 3 different things took place on, let's say, 8/23/94, entry number 9, you'll have 3 sentences or thereabouts. It doesn't necessarily have to be like that. But you can take, I mean, a raw beginner. I'm talking any one of you here who has never been in court before, with what you've learned up till right now, can take a master docket sheet off any given case out there, federal or state, and you can literally go down through here and see what happened in this case. And you can pull any document you want to. In other words, you don't have to get 600 pages of pre-trial motions to wade through them to figure out what's going on here. You just look at the master docket sheet and say, put in a motion to dismiss, a suppression motion, a motion in limine. Okay, I know what those are. I've got my Black's Law Dictionary. I'll look them up. Bang. You can review a case in a matter of minutes that if you had the actual documents you had to wade through would take you days. If you don't learn how to do anything else here, learn how to read a master docket sheet. Because if you do, you're going to find federal or state, you can get to the heart of a case just that quick. Some states, they don't call it a master docket. That's what they call it. They'll call it the criminal docket sometimes, even in the federal courts, master docket, register of action. But it's simply the day-to-day record of what's going on. It's the day-to-day index of what's going on in the case. Now, this next case, we're going to get into different types of actions. This first action here, at the beginning of this section, okay, section 3, all right, tab 5, this is an actual Bivens action. And the way that you know it was a Bivens action is because even the government attorney could recognize it as such. You know, this case, if you get the master docket sheet for it, let me give you a little background on this. This fellow, Thomas R. Lawrence, he's a chiropractor out of Denver, and this guy's good, by the way. You know, he's cracked me a couple of times. But what happened was Lawrence had a partner who was an osteopath, and the 2 of them had a clinic. I mean, these guys were on the cutting edge of medicine and chiropractic and everything else. I mean, they were doing chelation therapy. They were doing all kinds of off-the-wall stuff, and people were really happy with them. Well, there was an FBI agent named Peters, and Peters got it in his head that he was going to trash this operation. And what this whole thing was about, if you go into the statement of the case here, it will tell you what happened very briefly. You'll obviously get a lot more if you read the pleadings and that sort of thing, which you will have the opportunity to do. We're just not going to read them for you here word for word, because then we'd be here till this time next week. But what happened is that Peters, this FBI agent, decided, he and an assistant U.S. attorney named Brenda Taylor, and you'll notice they're both defendants on this case, both the assistant United States attorney and Peters. They decided not just to put Lawrence and his partner out of business. They put so much stress on his partner, who was an old man. He died of it. He basically died because of all this government-induced stress. But what's going on right now, as I've said earlier in this seminar, is that the federal government and the legal system basically have degenerated into a form of land piracy. And what happened, or what has been happening, is that a lot of medical practitioners, I notice there's a couple of doctors here, you may be next, but whenever the government sees what they perceive as a pile of money someplace, they go after it with all the gentleness of a great white shark. And they misuse the legal system in order to force people, to terrorize them into settling. Because Lawrence, of course, the first thing he did was he hired a lawyer, which is what most people do. It's the absolute worst thing you can do when the feds come after you, because as I see a lady nodding her head in agreement back there, as an attorney in Texas once said, and this was just last year, don't remember the fellow's name, but he said, now here's what you want to do. He's given a seminar to attorneys on how to handle a criminal case. He said, in a Texas state criminal case, you have to do this, this, and this. He said, and this is what a good lawyer will do. He said, but in a federal criminal case, he said, you don't need a lawyer, you need a priest. Okay? Well, it's the same way in a federal civil case, because no lawyer will do what you're about to see from this point on. They wouldn't dare, because remember, they have to feed at the same trough the next week, the next month. If you get sucked kicking and squealing into the federal court system and you want out, you don't care who you have to bite to get out of it. You don't care who you have to irritate. You don't care whose career you have to destroy. You could care less if you don't have a good working relationship with the U.S. Attorney's Office. You just want to win. And so there are things you can do that no licensed land shark is going to even consider. Well, in this particular case here, the first thing this attorney did that Lawrence hired is, first he billed him something like some obscene amount of money, like $300 an hour, to review what Lawrence and this osteopath were doing. In other words, he basically charged this poor guy $15,000 to learn what kind of medicine these guys were practicing. Well, that wasn't the issue, all right? The issue here was that the FBI had accused Lawrence of Medicare fraud. Well, what had actually happened was Lawrence had a bookkeeping service, and I'm sure some of you had bookkeeping services that basically they shouldn't be allowed to play with tinker toys, let alone get in the back of a computer or an adding machine. Well, he had one of them, and this girl had fouled up his books. Lawrence and a couple of his employees had gone to a seminar in Denver to learn how to comply with what they were supposed to bill Medicare for and what they weren't. And so Lawrence figured out, okay, he owed Medicare about $4,000. He went and had a meeting with a Medicare representative the day before the FBI tossed his place. I mean, when I say tossed it, they went in and they took everything. It's one of these, snatch and grab raids that the government is so famous for. Well, after this attorney has been through Lawrence's 15 grand, he comes to him and says, look, he says, here's how we're going to settle this. He said, the assistant United States attorney, now bear in mind, this guy hadn't done anything, all right? I mean, the guy was completely innocent. Not only was he innocent, he'd gone overboard to try to make sure he wasn't cheating the government out of anything. He said his attorney, and you'll see his attorney is the third defendant on this puppy, his attorney tells him that, well, Brenda Taylor has agreed that you'll only have to do a year and a half in prison and pay a $115,000 fine. That's a little stiff if you're pure as a driven snow, okay? So, of course, Lawrence, he's at his wit's end, and he ran into one of my people in Denver who invited him to a seminar and learned how to fight back, okay? So instead of taking, I mean, he didn't have $115,000. Remember what I said about land piracy? And, of course, the assistant U.S. attorney was using this as leverage. In other words, trying to induce fear in this guy. Well, if you saw this guy in person, real nice guy, but he has the face and the physique of somebody who looks like he's muscled for the mob, okay? Guy is not a trembler. So he decides, screw this. He says, I'm fighting back. Well, he knew how to use the weapons. So he filed this particular lawsuit. Now, this lawsuit has not been settled at this point, but the one thing I can tell you, the lead defendant was taken out of the field, and he's now flying a desk job in Washington, D.C. If you read the actual statement of facts here, and like I say, it's not something that I want to read you word for word here, but it tells you what happened in this particular raid and the obscenities that this particular agent used against Mr. Lawrence and so forth and so on. And of course, when Lawrence didn't lay down for the prosecutor, the attorney resigned because he apparently did not want to go where this case needed to go. You can get the master docket sheet. In fact, there's a service called Pacer. I'll try to get you a little more information after the next break, where you can literally pull up master docket sheets from almost any case in the federal courts through the United States, and you can read this, where this case is right now. Well, I don't know, I'll have to, yeah, well, it's on the internet, but I'll have to ask Diane exactly how I get on, because you're looking at a computer cripple here. It's like Peter said, you know, I'm from the 13th century. I don't understand this modern stuff, okay? But then, of course, his attorney bailed out because he wouldn't give the government $115,000 that he didn't owe them. And the government never should have brought this case in the first place, and he wasn't guilty of anything. But that's irrelevant in today's courts. And then, of course, here's the legal claims. Well, one of the things that and this, you're going to see this particular case is not laid out the same way you would a normal case. Okay, it's a RICO case, so it's somewhat different. But one of the things that you're going to see here in this particular case is that this is a pattern. In other words, remember what I was telling you about the legal system in the United States has literally devolved into land piracy? Well, Lawrence actually quotes newspaper articles where some of the big boys, I mean, we're talking the big hospitals and that sort of thing, the feds are coming after them and they're capitulating. They're literally paying the extortion, because that's what it is. They're using legal process to extort money that's not owed against American citizens, not because they did anything, but because they own something. And there's a world of difference here. If you look here, you can actually connect the dots on a RICO. All right, and one of the things that we brought up here was we asked for declaratory and injunctive relief. I'm going to be shortly showing you the difference between what they call an action at law and an action at equity. Here's the RICO, the enterprise. Remember what I told you about the elements? Okay, you'll see them listed in here. Here's the relief requested. And the next thing that you're going to see here, which is something that if you've got any property, you better learn how to do this. It's not hard. It's called a motion for return of property. It's a federal rule of criminal procedure, 41E, but you don't have to have a criminal case in progress to file it. Of course, no matter which way you do it, there's two different ways. You can do it in the case or out of the case that you filed. But whichever way you do it, the U.S. Attorney is going to come back and say you're wrong, because to them, it's not what's right or wrong, it's a game. And basically, you're just the victim of the game. But anyway, take a good look at this motion for return of property. Peter tells me I have about, there's a memorandum of law that goes with it. Normally when you do a motion, put a memorandum of law with it, shows you how to do that. My earlier seminars will show you much more about that. And then right after the break, we're going to get into one of my favorite cases, because it's mine.
And we are the Erwin Rommel School of Law, and we are at P.O. Box 211 in Atwater, Minnesota. 56209-0211 is our Babylonian commune number. Our telephone is 320-857-2400. Our dedicated fax is very dedicated, accepts only the fax, and it's 2401. We are on the internet at http://members.aol.com/Rommel-Law. This is our free information pack. If you don't have one, it's the Irwin Rommel Bookstore, A to Z, soup to nuts, and more. We're going to take a short break, and we'll be right back.
All right, before we get into Brown versus Reno, or as Peter and I affectionately refer to as Pigface, I want to give you a little bit on PACER here that I was telling you about. PACER is the Public Access to Court Electronic Records Service, which allows for retrieval of electronic case summaries and docket information. All right. The PACER system is available days, nights, and weekends. The cost for the service is 60 cents a minute, and access is billed on a quarterly basis. You want to pull up a court case, see how it's going. You can get the whole docket sheet in just a minute or three. And if you would like to register, you can contact the PACER Service Center at 1-800-676-6856. Anybody wants any more information than that, I'm going to leave this up here so we can get back to business. You can just come up here and write it at the next break or lunch or whatever. Okay, now, before I get into Brown versus Reno, I'm going to have to explain the difference, which I promised you earlier, between an action at law and an action at equity. Now, the reason these two cases are in here is because Tom Lawrence's is an action at law, mine is an action at equity. Unbelievable. He's actually here. Tom Lawrence, would you stand up and take a bow? Okay. One of the... I can tell you, this is one of the best chiropractors in the country. Did you bring your board with you? Oh, excellent. Okay, yeah, well... Okay? But the first case, in order to teach these scumbags some manners, Lawrence versus Peters, what we did is we asked for money damages, because the theory is that when you have a federal agent and he goes beyond what he's authorized to do, for example, one of the things they did with Lawrence here was this agent, basically because Lawrence was giving him a ration of crap, the agent pulls back his jacket and says, "You've got no effing rights." Okay? Well, that's on the lawsuit here. And of course, the U.S. attorney comes back and says, "Well, he's a bodybuilder. He shouldn't be afraid of this agent." Let me tell you something, people. I don't know about you, but I see a little old lady with a .38 special. I'm afraid of her. Okay? Now, his is an action at law. Action at law, and it's actually kind of kapakahi the way they have this, which is a Hawaiian word for being all screwed up. An action at law concerns money damages. All right? And a lot of these people, you're not going to get money damages from. Now, the other type of action, it's called an action at equity, or an equitable action, or you're looking for injunctive relief. Remember what I showed you earlier? That judges are not immune from injunctive relief. Okay? Now, what you're looking at in this next case is equitable relief. I don't want the money. All right? I'm asking the court to declare the rights of the various parties in this case. And if you look at who the defendants are, first, of course, there's our favorite Attorney General, all right? Then there's the head of the BATF. Then there are 2 United States attorneys for the Eastern and Western Districts of Missouri. And then the last guy is this BATF agent who fell right in the trap that I set for him. That's one of the things that you learn in this school, is you learn how to set traps. It's just we're not going to cover that much of it in this particular seminar because I covered it in the previous ones. All right, statement of the case. Now, bear in mind, I had a felony conviction from 25 years ago. If I get caught with a firearm other than an antique, like a black powder weapon, percussion ignition system, flintlock, whatever, I go back to the pokey for another 10 years. It's a ridiculous law, and it is unconstitutional, which I will show you directly. What it says is, plaintiff Michael H. Brown is attempting to acquire a firearm with a reliable ignition system that will not subject him to federal prosecution due to his prior federal felony conviction 25 years ago. And if you think they won't bang you for something that happened 25 years ago, let me disabuse you of that notion. They will not only do that. I have come across cases like one poor slob up in Vermont or someplace like that that was caught with 3 or 4 bullets. All right, I don't know what he had them for, just 3 or 4 bullets. He had them in his pocket or something like that. He'd had a felony conviction in 1961. They caught him last year with this, and he's now doing 10 years. In other words, these people that run the legal system are doing everything they can to disarm the rest of us. They disarm us. They kill us before we're born. The legal system did that with Roe versus Wade. And right now we have the highest prison population per capita in the world. Well, that's all thanks to the legal system. As H.L. Mencken said back in 1922, that 90% of these useless and vicious laws we have are the courtesy of the legal profession. And basically, obviously, what you're here to do is learn how to conduct the war against the lawyers.
And when he hears something, it's so cute the way he cocks his head. What? Videotape 3 for the week. Saturday morning, February 17th. This starts a new week of videotaping, folks. I left off videotaping on Sunday, I believe, but I didn't get all the news in on Sunday. Patty came down to see Franklin. Hi, folks. Tuesday, March the 27th was a good day. I edited at Lynbrook, and the editing at Lynbrook is always good. Everything always works. There weren't any delays. We did one program after another. We did 9 programs informing you of what's going on in your territory. And another nice thing is that while the programs were being edited on March the 27th, the programs were being cablecast on that were edited on March the 20th. And so we thank Amy Glembo, and we thank Pat Galino, and we thank Rob Kornfeld. That's very nice. It's good. It's good. And so I was done editing by 3 o'clock, and I trot up to Bethpage, and at 4:15 I made my 89th demand, exercise my shareholder statutory right to see the books, records, and minutes, and the shareholder ledger. Those are rights you have as a shareholder. And these are the rights that Charles Dolan is trying to take away from me, because Charles Dolan is doing something wrong and he wants to cover it up. One thing that's wrong is the shareholder list. The shareholder list, I have sent out 319 letters to 319 different shareholders. And out of those, something like 29 have been dead people, have been people who don't exist, have been phantom people, have been ghosts. So that's certainly one thing Charles Dolan is trying to cover up, is that he doesn't keep an accurate shareholders list and a correct shareholders list. I think the other thing he's trying to cover up is the fact that this is really not a public corporation at all. It's only a masquerade and a sham as a public corporation. It is really nothing but a family business, and Charles Dolan goes out and gets the public's money to buy stock. So that's another thing I think he's covering up. And so I asked Marie to make my demand known to the Charles F. Dolan office, and the Charles F. Dolan office, they never know anything in the chairman's office. They never know anything. And so I waited around, and while I waited around, I looked over the programs that had just been edited and the contents thereof to match up the right program with the right geographical area. And then I was told no, I could not see the shareholders list. Now, so my 89th demand was another violation by Charles Dolan. How many times has he violated it? Let's be generous about it. Let's see, 89 I made. I would say out of 89, 80, 75. 75 times he has broken the law. And so that's why he wants to get rid of me as a shareholder, and that's why this bully billionaire, Charles F. Dolan, is trying to rob this poor person, Glendora, of her 4 shares of Cablevision stock. That's poor Rusty. He has a cold. Poor baby. Thence I crawled in Long Island traffic up Route 135 north to Woodbury, where I handed in the 9 programs. They were received by Amy Van Horn, and that was philosophic. I asked to see the least access file and the public access file, and Amy said there was nothing new in the file since the last time I saw it. These winter cracks that you get in your thumb, there is a way to stop it. You just keep applying Pond's cold cream. Now I've tried other cold creams. I hate Pond's because they charge so much, and the man who owns the company is a fierce person, and I hate to use it, but I've tried other cold creams, and Nothing really works that I've found except pawns. And then Zarita was there, and Zarita is over at the building where Rainbow Sales is, and I asked Zarita about the FCC mandate to keep a public inspection file. You keep a public inspection file, and one of the things you have in it is the political sponsorships. And so I have asked for those many, many times, and I've been refused. So I did make a complaint to the FCC. It's on one of the telephone audio tapes. And but I've got to make a more pointed and more cogent complaint that Charles Dolan is in violation of the FCC mandate, the public inspection file. And from there, Acumen and I went west and north. We showed our signs at the Fox Neck Bridge that Citizens Against Tolls, our website, we hate tolls. It's terrible the way people rip us off. All they want is our money, folks. They keep taking our money until we are poor. Franklin didn't go because you knew that Franklin fell, but Franklin is much better. He fell on March the 9th, and I'm talking to you about March the 27th, and he's much better. It's amazing how he rebounds, and this is his 7th fall since 1997. I'd been up since 3 a.m., so I think I went to bed. I got home around 7 p.m. and I think I went to bed as soon as I could. There's so much to do, folks. There's just so much to do. It's the work of 6 people. I need a machine to do the work of 6 people. A man came home from work and said, at work they've got a new machine. It will do the work of 5 men. And his wife says yes. The machine that does the work of 5 men is 1 woman. Now Wednesday, folks, I apologize that I mislocated the battery of this camcorder. And I just found it this morning, about 6 days later. It was in the coffee cup inside the 8mm bag, carrying bag. And it's much better to videotape these things for you than to tell all about them. And so Wednesday morning, Franklin and I assigned all of the 9 editions, made sure that every edition had a cable company, and that every cable company had an edition. That takes a long time, at least an hour. And then Franklin wrapped them, and then I had to leave to go see Maria in Brad Sack's office, and Kevin notarized the, rather did the service on Dirty de Blasi, and Maria did the notarizing. She notarized my show cause why I shouldn't be robbed by Dolan of my 4 shares of stock, just to get rid of me as a shareholder because I exercise my shareholder rights. And that was done, and then I went over to the courthouse, 19 Floors of Injustice, the Supreme Court, County of Westchester, State of New York. Dilapidated courthouse with dilapidated people. And I went up to the clerk's office on the 8th floor. Abramovitz appeared in her obnoxious way, and I had just sued her. She's really nervous. She should be, because you don't go around violating people's rights. The courts are open to the public, and they're to be seen by the public. And that's the judiciary law, a statute of New York. Article 2, which says the courts are open to the public. And so Shirley stamped him. It was good to see Shirley. And she asked for Franklin. After all these years, they hadn't seen each other. That was nice. Yvette has gone up to be a clerk for Judge West. And Yvette's daughter is working in the clerk's office. So, and Yvette, of course, can't see this program because John Malone robbed Greenberg of system-wide public access. And Cablevision is in the medieval days as far as technology goes, and there is no system-wide public access in 20 towns in Westchester, big towns. Rye, Eastchester, Scarsdale, White Plains, Greenberg, Bronxville. There's no system-wide public access. The people are in the dark ages. And so I said, Shirley, I'll take this up to the chambers. And Shirley said, okay, take it up to the 17th floor. And I did, and I rang the bell. And Schwersky opened the door, and I came in, and I said, I have a paper to hand in. And he says, take it up to the clerk on the 18th floor. Now that's stupid, because where's the paper going to go? It's going to go to Schwersky. But that's how stupid Schwersky is. Barry Schwersky. S-K-W-I-E-R-S-K-Y. And I says, yeah, but you take note, okay, that I tried to hand this paper into you on this date. And so I went up to the 18th floor and around in the back. And wouldn't you know, and Schwersky knew this, that the second, whoever it was, the clerk, Jackson, wasn't there. Desk was empty. And Miss McLeod was next door, and I said, where is she? And she said, I don't know where she is. And so I went in and I left it on the desk. But it had been stamped with the clerk stamp downstairs by Shirley. So that's how devious Barry Schwersky is, working for dirty John P. de Blasi, Supreme Court, State of New York, County of Westchester. We got to get rid of de Blasi. We got to get rid of Schwersky. They're a public menace. You remember de Blasi? They caught him cheating. He was absent from the court for 31 days. Remember that? Instead of being in court for 31 mornings, he was in the Connecticut School of Broadcasting. So we got to get rid of both of those, and many more with them. What's next? A lot of people I hadn't seen in the Westchester County Courthouse, whom I've known for many years. It was fun to see them again. And a lot of bad things happened. The police state, and things like that. I don't know, see how people can do such unnice things all day and be nice. But that's the story of all of the courts. And so, that done, and the in-mail. The in-mail was outrageous, 24 pieces, too much work. And then back to the office with Franklin. in this short. Somebody in court.
Delaware Court.
Delaware Court.
Stay on the line. To ensure
Corporation.
where are you located?
In New York.
What's your phone number?
Now wait, what are you going to do?
I'm going to try. If I call back on it, well, I can try to switch you.
What number might I call?
If it's about, let me just look it up. You say
Yeah, it's a-
tax and political?
Yes, it's the public information.
Cable, with the cable companies, Margot Davenport.
Margot Davenport?
Yeah, I have to email her and give her your name and number, and she'll call you.
Okay, it's awful hard to get me at this place. What is her number? Could I call her? Margot Davenport?
Yes. 418-7200.
418-7200. Does she have an extension?
The secretary will connect you.
Oh, okay.
Okay? 202 area code.
Yes. Okay. What do you call a miniature guppy?
Excuse me?
What do you call a miniature guppy?
I don't know.
A microfiche.
Oh, my.
Thank you.
Okay, bye-bye.
Bye-bye.
Hang on one second.
Thank you. We're up to 45 calls today.
Hello?
Hello.
All right, hang on one second.
Oh, thanks.
Just need to get the book, ma'am.
Oh, that's good. I never can understand that book.
It's Springfield, Missouri.
Springfield, Missouri.
Okay.
This is library to get the name of the cable TV operator. Is that in volume 1 or 2?
I'm looking in one, but I'm trying to make sure that this is going about it the right way. I don't want to get you in the wrong
Yeah, that book drives me.
cable system. See, the thing is, it gives me a long listing. I got to flip through to make
500.
That's the phone.
That's good. I don't need the fax. And does it give the name of the general manager or any people?
Let me look through. Yep. Key personnel, Susie Winger,
Winger, I got it.
general manager.
Oh, that's good. And anybody else?
It also gives the technical manager, the officer, the studio producer,
Yes.
marketing manager.
Studio producer.
Okay. Studio producer is Richard Zane.
Spelling, please.
Richard, R-I-C.
No.
Oh, sorry, Zane. Z-A-N-E.
Z Victory?
Z as in zebra.
Oh, Z Zebra. Z-A-I-N.
Z-A-N-E.
A-N-E.
A-N-E.
Oh, that's good. That's very good. Anybody else? Does it say anything about public access?
Also check community access channels, 80 hours per week.
Oh, what's that? Say that again, would you please? Community?
It says that subscribing households, 54,000, 141 channels, 8 community access channels, 80 hours a week community access program.
Oh, wait a second. That's good. 8 community access channels, 80 hours a week,
Community access programming.
community access programming. Well, that's good information.
Okay.
Is that every day?
Yeah, that's pretty much
Now,
it.
you say that was in volume 1.
Yeah, that's in volume 1.
Okay, thanks. You know, that's a hard book to find things in.
Sometimes.
On Goldberg versus Cablevision, the Second Circuit has not made a decision.
Well, by some conscientious objectives at the end of World War II.
Oh, yeah. Telephone doesn't prove a residency, and therefore they'll take my program off of TV. So, will you, if they send you the papers, will you sign them as a resident?
Okay.
Okay?
All right. Does it mean resident or does it mean resident business resident?
Oh, the only thing that matters is that you live in Huntington. That's all that matters.
Were they really getting?
Oh, they're trying to get rid of us, Carl. Of course they are, because we explode. They're trying to get rid of us.
All right.
All right, then I'll ask them to send you the papers.
Okay.
It's just 2 to sign in 2 places. That's all.
Okay.
Okay, Carl.
Talk to you later.
All right. Did I tell you about the lawyer? No, did I tell you about the man in front of the judge?
No.
The judge says, "Why do you have Colonel in front of your name?"
Oh yeah.
Did I tell you that?
Yes, you did.
Okay.
God, I forgot. Go ahead.
All right, and the man didn't want to answer, and the judge asked him again. The man demurred, and the judge asked him again. And finally the man says, "Well," he says, "Colonel in front of my name is like the Honorable in front of your name. It doesn't mean a thing."
Talk to you later.
Okay, thank you. Bye.
about 1. Sunday, 12 a.m.
Kenny Milburn is still waging a campaign against you. Home address is 124 Kings Walk, Kings Walk, Massapequa, 11762. His number 795-807. He has it in field. He's been fired for physically abusing other people on the job. He has been indicted in corruption with union malfeasance. And he is mentioning you prominently, Glendora. I think maybe you should contact him at his home to let him know that maybe the upper hand is not always what it seems to be.
Sunday, 12.
I have asked Phil Goldstein in Fort Jefferson Station to be...
Hello, Lenny.
Hello, to be your local contact.
In where?
Fort Jefferson.
We did it, folks. This is the last report. And it's 4 a.m. I got up at 11 o'clock. I've been doing this for 5 hours. And this is it. And here's the here's a good joke for you.
When you do anything about for a long time, a battle is going on about NASA, and Brookhaven is all set. Gee. Okay, Chris. A man took his dog to the veterinarian, and the veterinarian performed tests on the dog to try to help him. And he says, I got one more test I want to do, and he went and he got his cat. And he had the cat walk around the dog, and the dog didn't respond. Well, the dog got better anyhow, that's good. And the veterinarian sent out the bill, and it was $250. It was $50 for the veterinarian and $200 for the CAT scan. And that's it. And now I'll try to sleep for an hour, get up at 5 o'clock, and go do the editing. We don't get paid for this, you know. This is all volunteer. About the loafing of the Delaware court. It took 1.5 hours, March the 11th, 2001, to make out Dolan's public access agreements, taking exceptions to all of his violation of rights, statutory and constitutional. Other cable systems who do not want to be empires and Napoleonic take just 15 minutes. There were more dead letters on Dolan's shareholder list that came back. And here's a picture of those. Glendora spent 35 minutes calling 411 on March the 11th to get telephone numbers of least access producers. Only 5 out of 10 had telephone numbers. That's another phony Dolan list. March the 11th, 2000, Glendora finished Dolan's oppressive public access renewals. Napoleonic, regimentating, imperious, law-breaking. They took 3 hours and $3. It took 1/2 hour to do Queen's public access renewal. See the difference? March the 11th, it took 4 hours and $27 to hand in new programs. A chat with Glendora. Pick up those cablecast at AOL Time Warner Public Access and at Brooklyn Public Access. The $27 is mileage. Executive Director at Manhattan Public Access does not agree with Tom Rogers. In 3 years there will be only one cable operator in the New York market. He says AOL Time Warner just started to build a new headquarters at Columbus Circle right up the street from where Manhattan Public Access is. Well, General Foods built a Taj Mahal in Westchester, and within a year General Foods was gobbled up by Philip Morris. Glendora's new stock certificate for AOL Time Warner arrived. She also got $22 for a fractional share. Franklin fell March the 9th. He is not able now to make demands to see the shareholders list, records and minutes. Number 89 has been adjourned. And that was page 6.
And here's a letter from the Delaware court saying that saying nothing really, and it doesn't give a case number. And Glendora tells the Delaware court that they're wrong to disobey.
They disarm us. They kill us before we're born. The legal system did that with Roe versus Wade. And right now we have the highest prison population per capita in the world. Well, that's all thanks to the legal system. As H.L. Mencken said back in 1922, that 90% of these useless and vicious laws we have are the courtesy of the legal profession. And basically, obviously, what you're here to do is learn how to conduct the war against the lawyers. Now, you go down through here, you'll recognize our old friend, Title 28, Section 1331. But then there's another couple of statutes here I want to bring you up to speed on. Number 2201, still Title 28. Anybody wants to look it up, it's right here if you want the whole thing. This is called the Declaratory Relief Statute, and 2202 is the Injunctive Relief Statute. In other words, you're asking the court to declare what the rights are of the parties and then to make the other side either do something or stop doing something. Well, what precipitated this declaratory and injunctive relief is before I have a firearm specially built for myself because of my legal disability, the fact that I was a bad boy once, at least according to the feds. You know, I think they shouldn't have made a federal case out of it, but they did. And what I'm asking a federal judge to do is declare what the rights of the parties are before I make a move and put myself in jeopardy. Because once I have a federal court order, remember what I told you about judicial estoppel? Once a federal judge says, okay, Brown, you can do this, this, and this, and you won't be violating the law, and then I go ahead and do it, and the same federal government tries to prosecute me for it, I say, whoa, wait a minute here, okay? I got an order from a federal judge. How come the law meant one thing one day in my case, and now it means something else? Now they got a problem, okay? But my insanity goes a little deeper than that, because if there's one thing a lot of ex-cons will pay for, and when I say ex-cons, we're not talking about the rapists, the kidnappers, the murderers, because that's a very small percentage of the prison population in this country now. most people are in the pound for what they call statutory violations. You know, they smoked a little pot. Maybe they got in an argument with an IRS agent, something like that. The guy didn't really do anything. It's just that they decided, okay, it's land piracy. It's time to board and loot. All right? Now, these statutes here are the ones that you use as the basis for declaratory and injunctive relief. No money involved, but you want to keep these people off your back. And remember what I said about fighting from a defensive position? Well, I just went on the offense here, okay? I mean, I basically picked a fight with these people by setting them up, and they didn't attack me. I attacked them first, okay? Now, finally, there's the Religious Freedom Restoration Act. Now, I'm sure a lot of you remember a couple of years back when the Supreme Court struck the Religious Freedom Restoration Act down as unconstitutional. But there's a catch here, because what nobody in the public recognized is they only decreed it against any federal action you take against a state government. Still applies against the feds, all right? Now, one of the reasons I raised this particular issue, and just, kind of follow me here for a minute. Oh, and by the way, paragraphs 4 and 5, these are principles you need to learn when you're going to do an equitable action like this, declaratory and injunctive relief, okay? One of the problems they're going to have with me is that under the Religious Freedom of Restoration Act, you have to show a compelling government interest in order to violate somebody's religious freedoms, and that includes the rituals and practice in their religion. For example, the Religious Freedom Restoration Act was enacted because a bunch of Indians were smoking dope. I think it was peyote up in Oregon, and they brought it. They brought this thing to federal court. United States Supreme Court says, yeah, Oregon can regulate that. These are just Indians. I mean, they don't have any religious rights. Who do these people think they are, okay? And so Congress, this was in 91. In 93, led by Charles Schumer, the biggest gun grabber in Congress, and this is going to be the funny part of it. Charles Schumer enacted or drafted the Religious Freedom Restoration Act. Said, no, if these Indians want to smoke dope as part of their religious ceremony, they should. And this should include all sorts of religious rituals and practices that the government can accommodate. Now, obviously, it didn't include things like cannibalism, because that would destroy the tax base. Couldn't have that. All right. So anything that's anywhere reasonable. And I'm looking at this, and I found that this didn't apply to the federal government in a case titled In re Young. You'll see it in here. Just came down out of the 8th Circuit, which is the area that I live in, just a few months ago. And I'm looking at this thinking, you know what? So according to this decision, the Religious Freedom Restoration Act, or RFRA, as the shorthand version is called, still applies against the federal government. And I'm thinking, see, I'm the last of the Puritans, okay? That's my religious persuasion. And the Puritans could not go to church without a loaded gun. All right, and I'm thinking, they've just deprived me of my religious freedom here with this statute that's listed on the same page saying ex-cons can't have guns. Well, they're going to have to accommodate me because I can't go to church without a loaded gun. All right? So, anyway, I went on a little further here and gave the facts, okay, about all these particular gun statutes, and you're going to see that here. This is the hilarious part of this, okay? Where'd Captain Simpson? Get over to your battle station, okay? There's a case called United States versus Miller, and here's what happened. I'll give you a brief background of the gun laws. How many people here, I'm not going to say whether you own them, enjoy firearms? Let's see a show of hands. Okay, that's most of you. Good, okay? Now, here's what happened. We got along fine from 1791 all the way up to about 1934, and Congress enacted a taxing measure on firearms that if you didn't pay the tax, you went to the pound. It concerned sawed-off shotguns. And in a case called United States versus Miller, I'm going to make this real brief because it's addressed elsewhere, the Supreme Court held that a sawed-off shotgun had no use as a military weapon. Of the 8 people who decided it, 1 was missing. 6 had never seen military service. The head of it, Charles Evans Hughes, was a pacifist. He'd been on the League of Nations and all that nonsense. Two of them were artillery officers who had never served in combat. They never left the United States in World War I. And Jack Miller and the other guy, Layton, these guys were hoods from the Western District of Arkansas, or actually they were from Oklahoma, went into the Western District of Arkansas, and they didn't appeal. The government appealed, and the government won it. Of course, you know, it's easy to do when you have, your opponent isn't there, you kind of forfeit it. And so the circuit courts of appeals have literally used the Miller decision to say that this particular decision says that the militia, in other words, the clause in the Second Amendment, which is a subordinate or dependent clause anyway, the militia, instead of being the able-bodied males, are actually the state militias, like the Highway Patrol, National Guard, stuff like that. Well, a fellow named Bradford Metcalf sued them over this issue. Peter, you want to hold up a copy of that lawsuit? Okay. Pretty well give you the idea. This is a civil case. He sued all the circuit judges in the Sixth Circuit Court of Appeals because of their judicial construction, fraud upon the court, that sort of thing. It's now pending in the Sixth Circuit. They don't know what to do with it because since a judge cannot sit in judgment on his own case, that's good, Peter, thanks. A judge cannot sit in judgment on his own case. They had to bring in a 3-judge panel from another circuit. And so now, as soon as they screw up, then we sue them, okay? But what all the circuit courts of appeals have done, and it's completely dishonest, they used the Miller case to say that militia means state troops. And that actually is not what the Miller case says. I defy anybody to read this Miller case. The citation is right there, all right? 59 Supreme Court 816. I defy anyone to read that and show me where it says that. But it does say that in a case back in 1905 from the Kansas Supreme Court. It's titled Salina versus Blakely. And the Kansas Supreme Court is the first court, not a federal court, a state court, to hold that the word militia in the Second Amendment means a state-organized body of troops. There's a statute on the books today, and you'll see it in the Metcalf lawsuit. It's Title 10, Section 311, Paragraph A, that will show you that the word militia, by statute, has been defined since 1792 as every able-bodied male between the ages of 17 and 45. Now, if you read the small, or rather the single-spaced here, and it shows you that you can't get this out of the Miller case that all the circuit courts of appeal have done, and this fellow Volokh is a law professor out in California. And if you read what he's got to say and you compare it to the garbage coming out of these Second Circuit Courts of Appeals, you're going to understand why I've been telling you that if you really want to learn this stuff, you'll learn it from the law professors, not from the judges. And that includes the ones singing with the Supremes. Okay? Now, if you go here to page 6 of Brown versus Reno, you'll see all the things that I'm trying to overcome because I'm not allowed to own firearms. You realize I can't even get a job as a security guard? You know? Not that I want one, but okay. All right. Now, so what I did was, I have a friend who's a gunsmith. And this guy, I got to tell you, is really, really good. And I went to him with this problem. I said, Steve, I got this problem. I said, I want you to build me a firearm. But I want you to build me one that isn't going to run afoul of these federal laws. So what we did was this. We took a cap and ball revolver. Anybody here ever shot a cap and ball revolver? Show of hands. 1, 2, okay, 3. All right. Well, it's not the thing that you put in the glove compartment of your car because it's an unreliable ignition system. You shoot the thing a time or two, the percussion caps split, they get lodged between the cylinder and the frame. Now you got to pull out another revolver. The powder can get wet. I mean, they're just a nuisance. They're just not reliable. They take forever to reload. So since Steve was a gunsmith and I was the legal eagle, I said, okay, let's do this. Let's go through the federal laws and let's see what's legal and what isn't. And there's a fellow named Michael Crooker out in Lompoc, California. Bless his little pea-picking heart. Did all this research. He just didn't know what to do with it. Okay? So he wrote an article for a newsletter that I have a subscription to and explained all these things about the federal firearms laws. So I wrote the guy in the newsletter, I said, you know what? I said, I think this guy's full of crap. Okay? So he sends my letter to this guy, and the guy says, what do you mean I'm full of crap? Here's all of the the exact rules for the BATF. Saved me just a mountain of work. I didn't have to read it myself, okay? So I'm looking at this, I'm thinking, okay, let's see. What's exempt here? Cap and ball revolvers are exempt. 22 rimfire blanks are exempt. Round balls are exempt. So what Steve the gunsmith did was he built a weapon. He took a cap and ball revolver, took the cylinder out, put a two-piece cylinder back in that you put 22 rimfire blanks as the powder charge. You get the hot loads, the number 6s. We use the 44 caliber ball. It's actually a 451. We use that. Now what I've got is I have a cylinder that I can take your standard 44 cap and ball Remington revolver, and that's the best one because you can just flip the cylinder in and out almost as fast as you can a magazine in an automatic. And we put this sucker in there, and now I've got a 22 rimfire blank pushing out a 451 caliber ball, and believe it or not, this thing puts a projectile out with a number 6 cartridge, 22 blank cartridge that you use in a Carpenter nail or stud gun at 750 feet per second. 45 automatic only does 900 feet per second. And if you get the tamer loads like the number 4s, it'll put that ball out there at 550 feet per second. And the beauty of this particular revolver is I can not only take the cylinder in and out just like that, I can carry spare cylinders with me. I can reload this revolver faster than anyone else can reload a police revolver. Now, problem is I don't dare take possession of this weapon until I get this thing adjudicated. Okay, so that's why, look under here in the definitions. What we did was we went all down through their definitions. We used their own law against them. We used their own regulations. And of course, this guy from the BATF, I had written the BATF. I started at the top. I got this flunky. And he's telling me what I can and cannot do. But if you compare the letter, right here, there's a multi-page letter. He's telling me what I can and what I cannot do. And if you read it carefully, you're going to see his answer is kind of schizophrenic. You know, one paragraph he gives me a right, the next paragraph he takes it away. So what I did was I took his letter, I applied the BATF's own regulations, I applied the federal statute and said, look, here's what I want to do. And what I did was, I said, okay, here's the way I want this to work, is number one, I want a federal court declaration that this revolver is legal for me to own. But number two, since firearm is defined by statute, not as a cylinder, but as a receiver, and this is not even a part of the receiver, I want the right to sell this cylinder in interstate commerce. And if you follow this to its logical conclusion, I may actually have a weapon here that's legal even for all you law-abiding types to take across a state line without a federal firearms license. Okay? In addition, of course, to rearming every ex-convict in America. But if you look at this and see what this will do is this will show you how you set up a petition for declaratory and injunctive relief, because it will show you how you take a letter from a bureaucrat. You can use this in any kind of a case. I don't care whether it's a tax case, a gun case, whatever, but you can take a letter from a bureaucrat, you can apply the regulations and statutes and rules, and basically you can get anything you want. Now, what I want a reliable weapon. But it went one step further, because I set another trap in here, and this particular trap, I got lucky. I used Volok's article to point out one of the things that I asked for in this case, if you look at it carefully under relief requested, is I asked that the federal court declare that these circuit court decisions, let's see if I can find this down here. See, under relief requested, you notice I'm asking for just about everything. You go down here to number 8, that this court declare pursuant to the provision of 28 U.S.C. 1331 that United States versus Miller contains no reference, direct or implied, concerning state militias or collective rights. Now, I just put that in there as kind of a red herring because I figure, well, I'm going to lose this anyway. But when you're up against United States attorneys, you're not going to get a clean win because they're going to win at any cost. So I figure, okay, I'll raise this one. And as long as, I'll be happy enough just to get a federal court order that says, yeah, this thing with the 22 caliber rimfire blanks and the 44 caliber balls in a cylinder, yeah, it's legal for you to own, okay? Hey, I got a gun, I'm happy, all right? I'll be even happier if I can ship this thing in interstate commerce, and of course I'll make a fortune. So I threw this thing in here about the Second Amendment as a red herring. And lo and behold, here's what happens in the meantime. And this is something that I think you might find of some interest. In fact, I'm going to leave this up here. You can pull this off the internet, by the way. Anybody who wants to, like I said, you can come up here, you can look at Pacer. Diane will give you the internet site for this particular case. You can pull it down on your own computer. Here's what happens. Some guy named Timothy Joe Emerson down in the Northern District of Texas, San Angelo Division, runs afoul of a federal statute. Now, remember what I said about judicial construction, where these judges change the meaning of words? Okay, militia meant every able-bodied male between 17 and 45. Now, because of judicial construction, it means state-organized bodies of troops like the Highway Patrol and the National Guard and that sort of thing. Well, that's the only thing that has been keeping us, literally, since World War II, from adjudicating a constitutional issue, okay? Well, here this guy, this isn't a divorce case, all right? I mean, this poor slob, he gets up in front of a federal judge, and he says, look, this is unconstitutional because it violates the Second Amendment. Well, you'll find case after case in which the judiciary tells you Second Amendment is not an individual right, okay? It's a state's right. It only applies to the state. Well, here's a federal judge in a 33-page opinion who says the exact opposite. He says militia means able-bodied males, and it is an individual right. Yeah, I see a man smiling back there, okay? This is the beginning of the end for all the anti-Second Amendment cases, because this judge belongs to the same circuit. Remember what I told you about the feudal system? Okay, sometimes it works to our advantage. In the Fifth Circuit, this is the same circuit that gave us the Lopez case. Any of you familiar with the Lopez case? Okay, I see a couple. Lopez was a kid who got caught with a gun inside a school zone. So the district court judge says, yeah, this has got nothing to do with interstate commerce. They took it up to the Fifth Circuit Court of Appeals in New Orleans. The Fifth Circuit Court of Appeals says, yeah, it's got nothing to do with interstate commerce. So these idiots in the United States Attorney's Office, who were, like I said, you know, Tyrannosaurus Rex, they took it to the United States Supreme Court thinking they had an easy win. Supreme Court says, yeah, this has nothing to do with interstate commerce, okay? So that particular statute, the Gun-Free School Zone Act, was struck down as unconstitutional. Well, this is the same circuit, okay? This is probably the most pro-friendly or pro-gun circuit in the nation, but they're still federal judges, so you got to watch them. But if this judge is upheld in the Fifth Circuit Court of Appeals, he has opened Pandora's box for all the gun grabbers. And if this one goes to the United States Supreme Court, you're also going to find that the minute the United States Supreme Court says the word militia means able-bodied males, this does not mean state militia, it automatically wipes out all this judicial construction we've had for generations about militia being a state-organized body of troops, which then allows people to litigate the issue honestly instead of running into this judicial construction. Because, and what this guy says, I mean, it's hilarious. I'm going to leave this up here in case anybody wants to thumb through it or get the docket number so they can pull it up on Pacer or whatever. Question on microphone. It's not time for questions yet, but go ahead.
Were you aware that, well, in the research that I've done with computer CD-ROM, that Title 18 said that a felon could possess a firearm as long as it was manufactured in his state?
That's already in here.
That's already in there?
Yeah,
okay, I was looking through it and didn't find it instantly.
No, it's there. Just look it up, okay? Look at the statute. As long as it doesn't move in interstate commerce, a felon can possess it. The problem is, let me tell you what you're going to, it's a good question because let me tell you what you're going to run into if you're not careful. If you have a felony conviction and you buy a weapon manufactured by the St. Louis, Missouri Arms Company, and it was one poor bastard found this out, the weapon was manufactured in Illinois, and they shipped it across the river, and they busted him on this statute, okay? But what this is going to do, and this guy points this out, it's hilarious, all right? He says, according to the Second Amendment as an individual right, it would also give us the right to own bazookas, machine guns. Yeah, I'm for that, you know, okay? I mean, they're individual weapons. But if you read this thing, you know, you'll find on page 27, he kind of steps on his tallywhacker here, because what he says and he's going to get caught with it at some point. I just know if anybody's going to be clever enough to catch it. He says that this guy, because he's in a divorce proceeding, you cannot take away his right to own weapons. But if the guy has a felony conviction, you can, because he's been given notice and blah, 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 even though he's talking about the Second Amendment. Well, you'll see all through everything I've written, in every case I've quoted, Congress cannot, merely by legislating, amend the Constitution. Because if you could take away somebody who had a felony conviction's right to own a firearm, then you could also take his right to freedom of speech, couldn't you? Or the right to petition the government for redress of grievances. There's all sorts of things you could take away, but how are you going to do that without amending the Constitution, which Congress does all the time by the enactment of statutes? Now, the last thing I want to point out here, and like I say, this is definitely some nifty reading. I mean, when I first read this, I thought, my God, this is the first federal judge addressing a Second Amendment issue since about 1941 that doesn't seem to have an absolutely terminal case of ocular rectitis, also known as cranial rectal inversion. Okay? Now, one of the other funny things about this particular case, if you read it carefully, this opinion and order was issued April 7th of this year. And if you read the citations in this case, and I don't know whether Metcalf had anything to do with it or not, but if you read Metcalf's brief, it's almost as if this is where he got his citations, out of Metcalf's brief that was done over a year ago. You might want to take a look at it. In other words, compare Metcalf's brief to this one. Diane? Pardon? Was it 3 years ago? No, it wasn't that long ago. No, it wasn't that long ago. But anyway, you'll find that this opinion and order is predated by the Metcalf case out of Michigan. Now, anybody, like I say, anybody wants to come up and take a look at this, you're welcome. In fact, I'll tell you what, since we already had one question, and we've got about 20 or 30 minutes left, and I know I've been going on and on and on, in a serious case of the runs of the mouth here. If anybody has any questions, why don't you line up at the microphone before I get to the next section? Anybody got any questions? Larry, you've got a question? I want to cover law journal articles next. Yeah. Pull it, no, just stand on it and pull it up. There you go. Yeah, okay. There you go.
And just hold it like this?
Yeah.
Mechanically challenged. My wife recently filed a lawsuit using the title 26 U.S.C. 7431.
That's the one where the unauthorized disclosure of information?
Correct.
Okay, yeah.
And they answered her. They didn't do the usual motion 12b6 and all that rigmarole.
Okay.
They actually responded to what her...
They actually filed an answer instead of a motion to dismiss. Okay.
Right. But at the end of the answer, they are asking the court to dismiss the complaint. Should she file a response to that answer?
Oh, absolutely.
Okay.
Yeah, absolutely. You never let these people get away with anything, because a lot of times what you'll see is you'll see something that you think is an answer, but it's actually a motion to dismiss disguised as an answer. And for those of you neophytes, normally what will happen is when you file a lawsuit and you get a reply, it'll either be a motion to dismiss or an answer. Okay? And that's all you're going to get hit with. I'm not going to go into that now. You'll get that on the previous seminars. But you never, ever let these people get anything past you. You always respond. And if you can't figure out how to do a response, if it looks like, okay, you filed a lawsuit, they filed an answer, you've come back with your response, and if you file something else, you're probably going to get tanked under the local rules. You can always come back with what's known as a motion to take judicial notice, Federal Rule of Evidence 201, and you can do the same thing that they do. You can just mislabel things. Works every time. Okay? Now, these 4 articles here are articles on Bivens. Remember what we said, Webster Bivens, what he went through, the action that is named after him is actually a federal civil rights action against federal actors instead of state actors. Now, some of these things that I'm going to read you a few of these because I think they're worth repeating, they're worth listening to in your car, and you'll understand what I'm saying about these professors writing these law journal articles are light years ahead of some of these crooked politicians that we also call federal judges making these dishonest decisions. Let me give you some examples here. And I'm not going to give you the citations because you have them there in front of you, and that's the last thing you need to listen to while you're driving along in your car is a whole bunch of string citations. What would be the measure of a right whose transgression carried no penalty? It would look more like a hope or a request than a guarantee. This girl who wrote this is probably the best Bivens article ever written. She points out, as I pointed out earlier, and I got it from her, that the Supreme Court did it backwards. Instead of using the Constitution as their authority, they used a statute authorizing the litigation of a constitutional right. The statute, Title 28, Section 1331, was passed by Congress in 1875. I guess what that means is that before then we had no constitutional rights. A right implies a correlative duty, and unless a duty is enforceable, it is not a duty but merely voluntary behavior. The Supreme Court is comfortable with the idea that rights may go unremedied and relies on injustices it has perpetrated in the past as authority for additional injustices. Ironically, what the Supreme Court has done in the name of separation of powers is to turn away from judicial review and allow the political branches to abuse their power unchecked. The province of the court is solely to decide on the rights of individuals. It's actually a court case. The Supreme Court did something right almost that time. A passive judiciary merely ratifies the status quo. Instead of acting as a bulwark against undue political power, it becomes an actor in concert with the political branches against the individual. When the limits of a statute thwart enforcement of the Constitution, the Supremacy Clause is turned on its head. For those of you not familiar with the Supremacy Clause, I believe that's Article 4, the body of the Constitution. What that says is that the Constitution of the United States shall be the supreme law of the land, any statute or state law to the contrary notwithstanding. If they actually obeyed that, there would be a whole lot of Supreme Court decisions that would have never been enacted. Now, I want you to remember this one. Now, this one, burn it into your brain, and I'm telling you why. Separation of powers is a political maxim, not a technical rule of law. Okay, separation of powers simply means that you have the legislative, executive, and judicial, and one branch is not supposed to encroach upon the functions of the other. And what will happen to you is when you write your Congress creature and you tell him you've got a problem with a federal judge, he'll come back to you, and actually it's not him, it's some staff scumbag. They'll come back to you with, oh, well, get a lawyer, okay? And we can't do this because it's separation of powers. Well, the reason you need to burn this one into your brain give me separation of powers because it's a political maxim, not a technical rule of law. And this is a court case. In fact, this is kind of a funny court case, this Adkins versus United States, because this particular case actually involved about 140 federal judges. And what they were whining about is they'd had a 34% inflation rate between the late 60s and when this case was filed originally around 1975. It's a Court of Claims case. Court of Claims is out of D.C. And they were saying, well, their compensation couldn't be diminished And they were whining about their income went from $42,000 a year with 34% inflation down to $25,000 a year, which of course was still more than they were worth. But they actually litigated this thing, and this was back in the days when they still published most of the cases, which I'm going to get to, as to published and non-published opinions. But you use this particular case whenever you're up against a Congress creature who tells you, oh, we can't get involved, separation of powers. You point out, look, separation of powers, it's a political maxim. Now, I defy anybody in this room, all right, to show me anywhere in our federal Constitution, Bill of Rights, the word separation of powers. It's a judicial doctrine because when this republic was founded, you'll find this in numerous documents from that era. There's even a really good book called Rewriting the History of the Judiciary Act of 1789, that in the original republic that we had, the federal judiciary was basically considered a body inferior to Congress, and it was kind of like an arm of Congress. In other words, Congress could do whatever they wanted with these people. And unfortunately, as Patrick Henry predicted, these federal judges have gotten more and more out of line to where now, like I said, we're back to the feudal system. Now this next one here, remember what I was telling you about that new statute, section 530B? Well, it's right here. Look at the bottom of the page where it says 530B, Ethical Standards for Attorneys for the Government. This ought to be a fun one because up until now there have been no ethical standards for attorneys for the government, and especially on the criminal side, you're going to see that government attorneys lie, cheat, steal, bribe witnesses, intimidate witnesses, suborn perjury, obstruct justice. I mean, these people do anything they can to win a case. You'll find that when you go up against them. Am I right, Tom Lawrence? Am I right, Larry Boland? Okay. I mean, these people will do anything they can to win, and they don't care whether it's nice or not, or whether it's kosher, or whether it's ethical. Well, now they're having standards basically shoved up their heinies, okay? And the second section there just basically says, okay, Janet Reno, here's what you're going to have to do. You're going to have to get some regulations to where there's some way that you're going to enforce this particular statute. It's basically how it is. Now, okay, now, the next part of it here, and there will be a couple of people tell you that I invented this statute, but I didn't. I just figured out how to apply it, and it happened right here. I'm going to tell you a little story. 2 years and 1 month ago, let me see all the hands of the silver will people. Okay, good. All right. 2 years and 1 month ago, I had a guy I was trying to help with on a criminal case out of California, out of San Diego. He was the first person out of the 422 people that Janet Reno indicted for defrauding old people. He hadn't defrauded anybody. I mean, the poor guy was just working in a boiler room, and what they claimed he was telling people, they had no recordings of, they had no witnesses, they had no nothing, but they just gaffled up 422 people, and he was in the first batch of 14. And we were in front of a judge named Rudy M. Brewster. We had a prosecutor named Stephen Peake, and of course then we had Alan M. Burson, who was the United States Attorney for San Diego. And I got to tell you, I was at my wit's end with this case. I mean, we had done everything. This judge was not paying any attention to the law. He was using the Constitution of the United States for toilet paper. At one point in this case, Bauer says, you know, Your Honor, he says, you got 14 charges of wire fraud against me here. He says, but you got no witnesses for 11 of them. He says, so I moved to dismiss the indictment. Of course, all the attorneys jumped up because they hadn't occurred to them. I mean, constitutional law is not an area that most attorneys are proficient in. And since Bauer was pro se, these 13 attorneys jumped in and said, yeah, Your Honor, we want to second that. We want to go along with this. We also want to dismiss the indictment. Just, we're not going to do that, okay? Well, I called for reinforcements here. And I told these people, I said, look, I said, I don't know what else to do with this judge. I said, so let's try to wreck his career, okay? I said, this judicial misconduct complaint, I said, let's just bomb him with these suckers. I said, I'm asking for volunteers. 30 members of Silver Will volunteered. Now, Silver Will is a multi-level organization, okay? And so what I said, here's what I want you to do. I want you to fill out these judicial misconduct complaints. I want you to get people in your downline to fill them out. And everybody you know, in other words, I want this judge blitzkrieged with complaints for judicial misconduct, because what happens on this particular program is that when you send in a complaint for judicial misconduct against a federal judge, it goes to the chief judge in the circuit. Well, this was a Ninth Circuit judge, so it went to Proctor Hug Jr., who's the chief judge there. And what they have to do is, when these things are logged in, they have to send one copy to the offending judge. So this judge is getting hit with about 20 or 30 of these things a day. I mean, there's 20 or 30 people all across the United States telling him, you're a jerk, okay? I mean, one of the statements this judge had made, and I had the transcript here, said, well, you know, when Bauer was arguing the confrontation clause, the ability to confront witnesses, you're not supposed to just charge you on an indictment and then just tell a jury, okay, convict this guy by supposition. You're supposed to have a witness or two. Well, this judge says, well, you know, the Constitution is a wonderful document, but it's terribly ambiguous. This moron had been on the bench since 1981. He didn't understand a simple constitutional provision, okay? So what we did was, we showed that this judge was incompetent, okay? And we attached the transcripts. And when we attached the transcripts, and I read some of the transcripts right here in this room 2 years and 1 month ago, and the Silver Wheel people picked it up, and we carpet bombed this guy. And like I said, what happens is that the chief judge takes one of those copies and sends it to the offending judge. So here's a judge basically being told by people all over the United States, you, sir, are a moron. Okay? Well, Bauer was up for sentencing April 21st. I said, you know, I told him, I said, Bauer, I said, you're going down, okay? I said, you'll probably win an appeal. I said, but you're going down. And he said, yeah, Brown, he said, I believe you. He said, this judge hasn't done anything he's supposed to. Just been a naked misuse of power from the time this case started. Well, at the same time, we had even filed a RICO action against this judge, all the other district court judges, and the United States attorney, which I'll get to in a bit. So Bauer goes up for sentencing April 21st, and I'm thinking, you know, I don't want to know what's happening here, okay? Don't want to know. Calls me the next day. He says, Brown, he says, I don't believe what happened. I said, what did happen? He said, this judge did a 180. He said, this wasn't the same judge. He said, the first thing he did, Bauer's going in there to argue on bail pending appeal. He said, the first thing this judge did was says, there's 14 defendants here. I'm sending you all home on bail pending appeal. Of course, the prosecutor's arguing about this, that, and the other. And the judge turns to the prosecutor and says, look, he says, Mr. Peake, he says, there are some serious constitutional issues here. There's a confrontation clause issue here. I am not sending anybody to prison. I'm sending them all home, bail pending appeal. And Bauer says, you know, Brown, I don't understand what happened. He said, this judge was talking more about the Constitution and the confrontation clause in a 90-minute sentencing proceeding than he did in 10 weeks of trial. And then I explained to him what we did here. And he said, oh, somebody held him accountable. Okay? Well, I'm going to ask you here, all right, to do the same thing. I know there's some people that have organizations of their own that are fairly influential. And I have another case. Actually, I have two. Time to break? Okay, I will tell you about the air support I am requesting from you people right here after lunch.
And we are the Erwin Rommel School of Law. We're P.O. Box 211, Atwater, Minnesota, 56209. Our phone is 320-857-2400. And our internet address is http://members.aol.com/RommelLaw. We're going to be gone for lunch for 75 minutes, and we hope you have a nice lunch too. Thank you.
Okay, what I'm going to do before I get into Operation 372, which I told you about our smashing success in San Diego, we also filed a RICO in that case. I'm going to get to in a minute. One of the things I want to caution you on, remember what I told you? Civil cover sheet, summons form, and complaint. Well, there's two ways you can sue somebody. If he's a federal actor, you can sue him in his individual capacity or in his official capacity. And these people pulled all kinds of stunts to get out of service of process. So Congress, about 93, you'll see it right here in the Federal Rules of Civil Procedure, Congress enacted a portion of Rule 4. Now, Rule 4 covers service of process. And you better learn this and learn it well. Because what winds up happening is if you file a complaint, you get a docket number, the thing isn't served properly, in 120 days, they tank your case. You know, maybe they think, yeah, so what, I can do it over. Sure you can, provided the statute of limitations hasn't run, okay? Most places, that's only a couple of years, because in a case in which you have a federal complaint, but there's no federal statute of limitations, and federal statute for RICOs, 4 years, you'll see it in your course materials here. Or almost for a Bivens action, it's normally 2 years. You're going to see what they did to us on one of these cases. But I want to caution you on something. Remember I was railing about judicial construction when this started? Now, Larry Boland brought this to my attention, and it's this. Congress changed the way that you serve federal scumbags in 93. Today, all you're supposed to do, by the rule enacted by Congress, is send the civil process clerk your complaint by certified mail for the district that you're suing in. And then, of course, the individual actors, you also send them a certified mail copy of the summons and complaint. Well, what this rule was supposed to do was knock out all this nonsense that the feds had come up with, like, well, if you're suing them in their individual capacity, and I'm going to warn you, you get no money damages on their official capacity. That's why, and I want you people who are involved in similar cases, and you have a little homework tonight, I want you to read at least one of these RICOs that will apply to you, okay? Anybody suing on a Bivens action for money damages, I want you to read Tom Lawrence's case. I want you to read the facts. I want you to read the law, the legal claims, the relief requested, and if you have questions on his case, I want them tomorrow. Those of you who think you're going to have an equitable case, you just want the court to declare the rights of parties, you read my case, Brown versus Reno, okay? And whatever we get to here, and I'm not saying I want you to read all this stuff, but I'd like each one of you to take one case that you think might apply to you, okay, and read it and see if you understand the principles. If you do not understand the principles or how you connect the dots, you get up here. This is what you're paying for. This is what I'm here for, okay? Let me straighten you out because other people are going to have the same problem. Anyway, on this particular rule where they took out service of process, and incidentally, when you're suing for money damages, federal or state, you always sue the person in their individual capacity because they've got all these procedural gimmicks that they're going to use to derail you. Equitable relief really didn't make any difference. Now, Larry Boland brought to my attention a case out of the 7th Circus, okay? Now remember, Congress changed the way that lawsuits were supposed to be served against federal employees, and that's all the way up to the president, all the way down to the federal dog catchers, in 1993. Now here's a case out of the 7th Circuit. This is from 1994. And this case basically quotes cases from 89 and 90 saying, well, no, you have to do it this way. You know, Congress enacted, I guess, doesn't count. They just changed it back. You know, Congress grants and the courts taketh away. So anyway, it's Rule 4, Federal Rule of Civil Procedure. Ignore it at your peril. Okay, now, I want to talk about just a little bit before I get into massive retaliation, because that's what we're about to discuss here. This is what you came for. There are two areas that you can use to retaliate that are pretty effective. First is the judicial misconduct complaint. We discussed that before Chow. This, of course, these are the RICO statutes that I pointed out to you earlier. Now, one of the things that happened in the Bauer case, and again, this is where we basically launched our massive counterattack against federal judge Rudy M. Brewster. At the same time this counterattack was going on with judicial misconduct complaints, Bauer filed a RICO action against all the federal district court judges. You will see the entire complaint in the book over there. It's called Son of Erwin Rommel. And the whole complaint is in there. You want to see how to lay out a RICO complaint against federal district court judges and United States attorneys, it's right there. Now, of course, this thing got tanked, okay, because they always do. But here's the hilarious part of it. In the first place, when it got dismissed, okay, it went up to the Ninth Circuit Court of Appeals. Now, Bauer, at the same time, bear in mind he's out on bail pending appeal. What Bauer's appeal judges did was this. They threw the RICO from San Diego, all right, went up to the Ninth Circuit Court of Appeals. If you pull it up on PACER, this is not a published opinion, okay? This is something that you'll basically have to track down to verify what I'm saying. And you read the order issued by the Ninth Circuit, it's gibberish, okay? It's an unpublished opinion. We'll discuss that in a few minutes, okay? And anyway, here's what happened. They assigned Bauer's criminal appeal, not the RICO, the criminal appeal to a 3-judge panel. Well, another 3-judge panel passed it on, or rather another 3-judge panel got it from the first 3-judge panel because the first 3-judge panel said, oh, well, no, we need to schedule this one for oral argument. So it went to an oral argument 3-judge panel. And that's how your appeals are decided. They're decided by 3 federal judges at the Circuit Court of Appeals level. And then Bauer says, oh, okay, this is great. I want to argue this. So he called up the court clerk and said, look, I'll be there for oral argument. Well, when they found out that Bauer was going to show up for oral argument, they decided they didn't need it. So they put it to another 3-judge panel, okay? So far, just over the oral argument issue, been through 3 Court of Appeals panels. Finally wound up on a 4th one and hasn't been decided yet, far as I know, okay? That's not the good news. The good news is this. What I told Bauer from the beginning, I said, look, I said, you're going to get shafted, okay? I said, you can take this one to the bank. I said, but here's the way we're going to do it. I said, let's go all the way through this RICO business against the federal district court. I said, and while this is going through the federal district court, trust me on this one, you will get shafted in the Ninth Circuit Court of Appeals. I said, and when you do, because that's obstruction of justice, when they don't give you what you're entitled to in the federal courts, which is a predicate act under RICO, and they've been doing it all along, I said, then we RICO the Ninth Circuit Court of Appeals itself. Well, I don't know, I think he kind of lost interest at some point because he's still on the street. It's been 4 years now since this case started. And he never got around to that, but by the same token, they never got around to locking him up either. And I think what happened was the reason these judges kept passing this thing like a hot potato is they figured they were next, and they were correct. In fact, if you study the Bauer case in Son of Erwin Rommel, you'll see exactly how everything fits together. Okay, now, but here's the bright side of this. Now, some of you who've had experience in the federal courts understand what you're up against with United States attorneys. Okay. These people are the scum de la scum, as opposed to the creme de la creme, okay? And these people, they're political appointees, and every United States attorney wants to become a federal judge. Here's the problem. When you come up for a federal judgeship, there's an FBI investigation that's conducted. It's number 1. Number 2, and I've only run into one exception in the last 10 years, and we kind of halted his career in mid-stride. In Sacramento, a fellow named David M. Levi, he's also in the books. There are 3 names put in a nomination. Now, let's say you have a United States attorney, you have some scumbag politician who also is a lawyer. You don't have to be a lawyer to be a federal judge, by the way. There's nothing in the Constitution that says so. It's just that the lawyers have taken over the government. And let's say maybe you have another United States attorney. Okay, so you got these 3 people, their names are put in nomination for one of these judicial plums. And what winds up happening is the FBI brings all this dirt. Now, the easiest way to bring dirt on a candidate for a judicial position is just to go through his court cases. How many times has this guy been sued? For what? How many complaints of one sort or another have been filed. I mean, it's a matter of public record. Well, you're going to see that in the case of the United States Attorney in San Diego, a fellow named Alan M. Burson, Bauer documented everything this guy did wrong, where he committed one felony after another. They all do it. The difference is that the felonies that they committed against Bauer all had a docket number. And they were all a matter of public record. Anybody could access just like that. The good news here is that though Bauer didn't win the RICO in San Diego, Mr. Burson must have figured he was no longer a viable candidate to be a federal judge, and as of March of last year, he resigned as United States Attorney to become a public school superintendent in San Diego, which is kind of like being promoted from United States Attorney to janitor. Now, I want to get into these complaints for judicial misconduct. First thing I want to point out here, now turn to, you're at section 8 here. I want you to look at this case here. It's in the second paragraph. Okay? Now this is a sample 372. I'll explain how we got here. And it's, see this case site where it says In re complaints of judicial misconduct? According to this